Wait.
And then
still starting. If its sound is working or not.
receiving your content. Almost ready.
You are live. Okay, so I will check it if the sound works.
Oh, and check please if the do you have the link already?
No, I need a link.
If, okay, so sound check. And then
Keine Wahl. Ich warte noch.
Ich schätze so 7.
Schau mal jetzt.
Wahrscheinlich müssen wir mal zumachen.
Yeah, so
Manchmal
no, it's not working, so we have to always click on the presentation.
Okay, and then it's working.
Yeah.
Okay.
Is it just the presenter stick that is not working?
No, I think it's working, but we have to click on the
cursor has to
presentation.
be
Okay.
Yeah.
here. Now, please try it again.
Not doing anything.
Where is the presentation? Here?
Yeah. Good question.
Morning.
Yes, the stick is in, right?
Yeah, this is
one. You know what you can try? Close the presentation.
Yes, it is.
Really close
Okay.
it and then open it up again, because then the stick connects and realizes there's a presenter. Food, we got drinks.
Or if we export it to PDF and we use PDF, maybe.
I think let's try once more, I think.
Noch schnell das einstellen. Set up section.
The last one.
Okay. Jetzt mal gucken.
Yeah.
Macht er? Macht er nicht?
No, but click on it.
On the presentation.
Click on the presentation.
Yes?
No? Right?
No.
Wir können noch einlassen, wir können es nochmal mit meinem. We can try mine. That one maybe. I don't know.
Correct.
Okay.
Wenn ich das
Okay.
Or we can do it like manually, that I will change the slides.
Ist der Grundaufbau immer JS? Also diese App
Yeah, den Presenter.
Das ist die Serverumgebung. Und die ruft dann integriert das Server konkrete Namen verwendet. Und das Express, das ist ja dann da. Und die MongoDB, die müsste man wahrscheinlich dann in der FJS reinmachen. Ja, genau. Aber die läuft ja quasi also die muss extra starten. Ja, nicht nach so. Dann hat man ein
So let's look at a couple of principles. I already gave an example. Personal data could be contact details. It's in the law explicitly written that you're allowed to do so. So you need to be the basis for it. In the United States, it's the other way around. If you have personal data, you can use it unless someone says you're not allowed to. Right? So rule and exception is upside down. In the European Union, it's the stricter way. Data protection is a European topic. In fact, it came from Germany. Germany was the first country that introduced data protection laws back in the 70s. But in the 90s, I think in 95, we had the first new directive on data protection. This is still in play. This still exists. It's going to be removed in May 2018 by General Data Protection Regulation. We'll talk about that in a second. But right now, there's still a new directive on data protection, which determines the application of data protection laws in all of the new countries. However, every country has an own data protection legal framework. So, meaning, when you set up a business model and you target the German market, and you have your But if you now look at 4% of the total work of annual turnover, and now you think of time, how much more? And we're not talking 20 million. We're talking much larger, right? And so this is basically the topic why everyone is looking at GDPR, that Unified Data Protection Framework, because the fines are so high. Before, nobody would really have cared. Well, of course,
This should be like the top right now.
And as I remember, Google was, had a lot of cameras, and it was an internal issue.
Exactly.
So is there an external issue where, for example, somebody got the data of somebody, and
Well, there have been
was
There have been a few cases where data was corrupted when it was transferred to outsourcing providers. And there were a lot of cases actually, but none of which I'm aware of that they have been awarded monetary fines up to $1 million or something like that. So usually the fines were much lower than that.
But it's actually, we are working with a lot of corporates, for example, so it would be very, I don't think you're spying your employees, but maybe, especially in the collaboration with other companies, it would be interesting how do we work on that, because especially as startups, you don't have all the concepts and processes in a company, and how we can manage it internally so nobody tells about Bosch project or something. I think it's also like data that has to be protected.
Well, I would say that we'll come to the details in a minute, because there's certain proceedings that you already have to have in place right now. One example you just named: how can I make sure that my employees will obey data protection law rules? So the first thing you would usually do, even right now, you would have some sort of a guideline for your employees, right? So this is what most companies, and if you look at Daimler, I don't know how many guidelines they have on data protection. I would say they have plenty of them, right? For like all the different areas, how to share data, how to use employee data, etc., etc. Second thing in Germany right now, you usually need, once your employees come in contact with personal data, they would need to sign an obligation on data protection laws. So this is just a basic procedure in Germany. You have like a one-pager. Once you have to make them sign an employment contract, they have like another page, and they just saying yes, I observe data protection laws and so on. So this is like an additional making people aware of the fact that there's data protection law. Other than that, you should have trainings. Huge organizations like Daimler again, they have, I don't know how many different types of data protection trainings for the development guys, for the HR guys, for the IT guys, for whomever. So these are like the usual measures that companies will implement in order to prevent data corruption. I mean, obviously, if there's criminal energy and one of your employees wants to take the data and, I don't know, do whatever with it, that's not allowed. It's certainly hard to prevent that from happening. However, these are like the basic principles you would need to implement in order to make sure that you, as the company, as the management, that you have done your job, you have done your homework. Because then you can present, well, at least I tried. I've done everything in order to prevent it. If some individual is going to step out of that, then that's something you can really handle.
But then still the company can be fined, although they
Yes.
did everything and...
Yeah, it's a two-step process. So the monetary fines we're looking at right now, they're aiming at the company, right? So if one of your employees takes the data and sells it to, I don't know what, and it's personal data, then you will have a two-step procedure. Step one, you could be awarded a monetary fine as a company. Step one. Step two, the individual selling the data could have committed, in addition to that, a criminal offense, right? But that's then targeting the individual. You as a company management could also commit a criminal offense, a crime, right? Data protection law violations can be a crime, but these are usually very severe cases. Okay. And like the public prosecutors, this is something, once they start to look into that, then you need a really severe case. So haven't seen that in a long time, right? So coming back to why data protection and why data protection now and why GDPR, already talked about that, high awareness of the data protection authorities. If you need to imagine data protection authorities like that. It's as to size. Like for example in Hessen, I would say they have 25 to 30 guys working there in the field of data protection that are supporting like the companies. If you now think, for example, Hessen, I'm from Frankfurt, if you think how many companies are just located in the Rhine-Main area, and then you see they have 30 guys there working for all the companies, you can count through what's like the probability for you to become a subject of a screening, of an audit. So we did that once, I think a couple of years ago, and actually the resources at the data protection authorities, they haven't really changed. They didn't really man up in the meantime. So usually we would say you should think of one audit per, I don't know, 20 years maybe. even a larger scale. So, like the chance for you to become subject to a data protection audit is quite low still right now. However, data protection topic. Why? Because we're talking 20 millions now. This is a compliance issue now, right? Company management has to take care of that. 5 years ago, data protection was something down there in terms of like just take care of it. Right now, it's a key point for risk management and compliance management. I mentioned now a couple times that GDPR and the new legal framework comes into effect in May 2018. It's May 25th, actually. The GDPR, the General Data Protection Regulation, has been passed last year. But then they decided on a 2-year, let's say, transmission period for companies in order to adjust to the new requirements. And this transmission period is going to run out in May 2018. So this is basically the deadline for everyone to become compliant. Because starting May 25th, 2018, you have to be compliant, right? You would now say, well, my organization is quite small. You have a couple of employees, you have one major business process, and so that looks quite easy to implement the new requirements because your organization is quite small. But if you look now at a huge organization like a Daimler, that takes way longer than 1 year, right? Why would you look at data protection law right now? And I think like the key issue for you is going to be that. First, if you can show to your customers that you are data protection law compliant and you have a high standard for data protection, you have a high standard for IT security, it will be on the one side a selling point, on the other hand, it will be your general entry because some of your customers will not even get into business with you unless you can present that you are up to date with data protection law. Because if you're not, some of them will just say they will not work with you, right? 10 years ago that was maybe different, but right now, if you speak to a large organization, a big OEM, this is something they're going to ask. They want to see, they want to learn about your data protection experience. Is your model data protection law compliant, right? So, from that perspective, it's really crucial for everyone to look at data protection. And maybe one question back. Like earlier, we discussed your business models. Like, I would say that every one of you is to some extent processing personal data, right? If your employee personal data, let's leave that aside for now. You have customer personal data. Do you have business models where other than just plain contact data of your customers, you would receive other personal data from other third parties, from, I don't know, your customers' customers, for example, end customer data? Any idea? Would that be a use case? Any one of you?
In my case, probably.
Yeah.
Yep.
So let's say one of your customers is I don't know.
For example, we're building a charging point,
Mm-hmm.
and somebody, like an end customer, is using the charging point, so it was
So you receive, for example, the name, credit card data,
something like that.
location data. You could receive like a plate in terms of like what car has it been. See? So that's the use case where we're really talking data protection now. The other two use cases, employee data protection is, yeah, it's a topic for everyone, right? But it's already now a topic anyway, so this is not really new. The other topic is the topic data protection in terms of protecting your customer personal data. Like I said, that's B2B data, it's still personal data. Data protection laws will still apply, however, the practical risk is not that high. Here we're talking end customer data, right? And maybe even on a large scale.
Also, I can provide another example. Like I was working for SAP.
Mm-hmm.
We have to get inside the customer's subsystem and claims, and we need to handle all the passwords to get inside in a specific security place, where only password would be there, only us and the customer should reach that part, which is also critical because they can get into production system, but they can destroy everything.
Well, if I understand correctly, so what like every large service provider, may it be like AWS, Microsoft, SAP,
Usually when in the first step they sell their software, like a license model or SaaS model or whatever, like a web service or whatever. And the second step always is the servicing, maintenance, so that kind of stuff. And usually once you open a trouble ticket, you have an incident, then it could well be that you are going to have access to your customer's environment. And usually there's personal data in there, depending on what your customer does, right? Classical SAP topic, right? You get access to the customer database, so you have access to the entire customer data. That's a data protection topic, right? And you cover that usually by having SAP, for example, and the customer entering into a specific data processing agreement. So this is something that data protection law knows. So this is allowed. However, you need to have like the proper agreements in place. SAP, I know, has a very substantial set of agreements on that. So they're usually really good in doing this particular work. All the large providers are quite good at that, right? Because they know that they wouldn't sell their services really good to other companies if they wouldn't present like a high level of data protection. So like AWS, like Microsoft, they have standard agreements on that, right? But that's exactly, that's the case. That's data protection. Totally true. So when we look at data protection, you always look at a couple of different questions. The first question is always, I have personal data, and you would always ask, am I allowed to process the personal data that I'm having for the particular use case that I want to use them for? This is the first question you always ask. The answers to that. Second question, when I do that, are there any process or formal requirements that I need to obey to? The best example is that you always have to inform the data subject on how you treat personal data. So this would be like a process requirement. The third point is, in data subject always meaning the natural person the data is referring to. So for example, my name, my email address refers to me. In my email address there's Taylor Wessing. It's personal data in its entirety because my name is like up front, but Taylor Wessing itself has no meaning in terms of being personal data, right? It's a common name. No? But then there's the right of the data subject. So let's say, for example, you have like a customer database of your customer because you collect like all the driver's data. Now you have a driver of one car and they are going to approach you like one guy. He's going to call you up and say, I would like to know what sort of personal data you have stored referring to me, the natural person, in your database. These are the rights of the data subject. You can do that under applicable data protection law. Everyone has the right to do so. Now you need to ask yourself, do you have the means to retrieve all personal data referring to that particular one customer from your systems within a quite short period of time and with reasonable means? Or would this be something where you say, all right, that's going to be a hard exercise?
Probably.
Yeah, probably. So under GDPR, this is something where you should implement a process for it. Or at least have an idea how you would react to such a request. Because that's going to be a crucial topic under GDPR.
Well, in case this service would be outsourced to a sub-provider, means the back end would be provided by not our company, a sub-provider. So the issues are on their side.
You mean a sub-provider acting as sub-provider to you?
Yeah.
No, because you're still in control of the environment, right? So if you give your application to, I don't know, Amazon, to Azure, you have an Azure cloud, or you give it to, I don't know, to Bluemix, or I don't know what you need, right? Then you are still in control of the environment. It's hosted externally at a third party, but they are not in control of the applications, right? So you would need to make sure in the first step that you have the means to retrieve the data from that particular system. So it doesn't matter where it's hosted. However, of course, that third-party customer, and always think of that example of SAP, right? Once SAP receives all that data or has access, usually it's rather having access to the data, right? Like in the traditional model, unless you have a cloud system, right? In SAP you can always...
Yes, but the cloud is starting now, and when I was working there, I didn't have the chance to pay too much with
Exactly.
But yes, now like the security system like is provided by SAP and all the passwords and everything is handled by the company itself. The customer doesn't have access to it.
Right. But still, like in the cloud system, they would still host it. So they still have the physical control over it, right? That means they also have to obey all the requirements referring to processing personal data protection laws. But still, they're processor. So that's a different role. In your case, you would also be a processor for your customer, but in the relation between you and your backend provider, you would be sort of a controller again. So you would be in control of the system, so you would need to make sure that you have the means to, for example, retrieve the data. Again, and I understood your use case like that. Here's the driver of the car, here's your customer, like operating a network of charging stations. And then here's you're sort of like, you're the service provider for that customer in the middle. So in fact, it would be the obligation of your customer to make sure that he can retrieve all the data. This is how it usually works in practice. Why? Because usually the end customer doesn't even know that you're involved. Usually. They know, okay, there might be some service provider in the backend, but they usually don't even know your name. So the chance for like the end customer to approach you and ask for a set of data is relatively low. However, they could find out about it, right? And then they could approach you directly. In this case, the first step you would do, you would go back to your customer and would tell him about it. Why? Because usually you have a specific data processing agreement that is in place between your customer and you, because you're processing personal data on behalf of that particular customer. And one standard provision that is usually set in these DPAs, data processing agreements, is that if a data subject approaches you concerning, for example, access to personal data, then the first thing you should do is, or have to do, according to the DPA, you have to inform your customer about that. You have to collaborate and think of how are we going to comply with that. So usually it's the requirement that your customer is facing. However, from a technical perspective, you should always think of how could I offer that to my customer, because your customer will come and will ask you, how can we do that, right? So data access is one really crucial topic. I'll come to another topic in a second, which is quite similar. And this is a new model under GDPR. We didn't have that in Germany yet. It's called data portability. But I'll come to that in a second. So this is going to be a crucial one for you, for example. Sanctions and fines, we talked about that. We talked so much about like the definitions of personal data and processing and so on. So I just brought the definition as it is set down now in the GDPR. So let's take again the example with the driver, right? Maybe in your backend system you don't have no name. You don't. Maybe you.
But there has to be some identification.
Some identifier, correctly. It could be the VIN, right? But in your case, it doesn't really make sense to use the VIN as an identifier to identify a particular car. Could be, but not really necessary, I would say. But let's say you just have like a hash, right? That's the customer, and you have like one hash. This is your customer, and then you would have like certain parameters, like where, how much did he get, like how much gas, and how much did he pay, and So right now, the question you always ask once looking at, do I have personal data or not? You always have to ask, is that already identifiable information? Because you have a name, you have like a particular address, an email address, then you would say, yes, it's personal data, obviously. But if the only thing you have is just like aggregated data and then one identifier, and you don't have the means to find out what's the natural person behind that identifier, then the question becomes a little more tricky. In your case, you being a service provider to your customer, let's assume your customer can say what that natural person really is, right? They have a contract. This is a tricky question. 2 weeks ago there has been a ruling from the Federal High Court in Germany, and that was about IP addresses being personal data. So this is an ongoing discussion for years now. And this is now the final step, and the Federal High Court said IP addresses are personal data. So the question is now, if you show me an IP address, and you see like a line of numbers, I have no idea who's the natural person behind that IP address. The only third party who could tell me that is the access provider. So I would need to go to Telekom 1&1, somewhere else, and say, that's the IP address. Please tell me who was using that IP address on a particular day, at a particular time, Usually a couple of weeks after the IP address was used, even 1&1 or Telekom or whoever couldn't even tell you anymore. Why? because they have erased all the data that would allow them to reconnect the IP address to a natural person. Still, Federal High Court says IP address is personal data. In this case, it was targeted at a website provider. It's all about like how long are you allowed to store IP addresses as personal data and so on. So that's a bit particular case. However, right now the car has been produced and rolls out of the factory. The last 5 digits are awarded, and then they just go like 1, 2, 3, 4, 5, like depending on where the car's in line, right? So looking at the entire VIN, you could say there's a particular car carrying that particular VIN. So it's identifying a car. So right now it's no personal data, it's referring to a car. However, you could take the VIN and go to Kraftfahrtbundesamt and could ask who owns that car. So they can tell you that because they have a list, because they know who owns the car. Could be a bank if it's a leasing car, could be a company car, but it could also be my car.
But they're not allowed.
Exactly.
Because
they're not allowed. So if you try that, if you now go to, you have a VIN, and you go to Kraftfahrtbundesamt and say, I would like to know who's the person behind it. They will to 99.9% tell you, I'm not allowed to give you that information. However, VDA, Verband Deutsche Automobilindustrie, and data protection authorities say VIN is personal data. Right? So I think this is a very good example for you to understand that the concept of personal data is a very broad concept. Location data. Location data itself, just you have a car, right? Let's call it car 1. You just know it's car 1. You have 10 cars, 1, 2, 3, 4, 5, and car 1, and then you know just you have aggregated data, meaning location data. You can see it has like a profile. It goes from Stuttgart to Frankfurt, from a particular address A to a particular address B, once a week. Is that personal data? Well, maybe not if you have the information from 1, 2, or 3, or 4 weeks. But maybe if you have the information aggregated over a longer period, a couple of months, maybe even years, and you know, well, there's one particular car that goes from a particular address on every Tuesday. It could be quite easy for you to figure out who owns that car or who drives the car, right? Meaning, when it comes to location-based services or location data, there's always a risk, depending on how granular, how detailed the data is that you're obtaining, that it could even be deemed personal data, right? But it's always like the one particular case. You always have to look at the particular case. I would never say like location data is always personal data. No, it's not. It can be personal data. Depends on like what's the additional information that's available to you. Processing. Think of processing as everything. Looking at personal, you don't even have to really do something with personal data. And the data protection laws, let's take the SAP example. It's enough to just in theory have access to data. That is already data protection relevant. You don't need to do anything with it. This is why when it comes to maintenance, all the companies, they had to have these substantial data processing agreements just doing maintenance on systems. They would never even look into the databases where the personal data was stored, and however they had access because they needed to have access in order to do the maintenance for the software, right? This is still a type of processing. It's a type of processing, right? It's using personal data. You're not actively using it, but you have access to it, even in theory. That's already enough. You're already in the scope of the data protection. Now, 2 other concepts. Anonymous data and pseudonyms. Anonymous, from a data protection perspective, means there is no chance whatsoever to re-identify the data. And no chance meaning there's no one out there who has the key or additional information to help me to re-identify the data. This is what anonymous data from a data protection perspective means. So, just always remember, when you use the word anonymous data, think twice if it's really anonymous or if it's maybe just a pseudonym. If you have data and you aggregate it under a hash, and you can re-identify the data because you know how the hash functionality works, then it's no anonymous data because it's quite easy for you to turn back the clock and see what has been in raw data, right? This is not anonymous data. So always keep that in mind. like I said in the beginning, the first question is, you always ask yourself, am I allowed to process personal data that I'm having? Sorry for always coming back to your use case, because it's very good to picture like the basic requirements. So the first thing you could always do is you could ask the data subject for a consent, right? Consent always have to be informed and given by free will. Informed meaning, let's say I'm a driver, I use a gas station and you are the network provider in the back. It would not be you as a service provider to your customer to obtain consent from the end customer, from me. Why? Because we're not interacting. I don't even know that you're there. You're a technical service provider. But your customer may come to me and say, well, you want to use the gas station, there's data I'm collecting, I may even give that to service providers, so I want you to consent into that particular processing of personal data. It's possible. It's not really clever actually. Why? Because you can cover that processing of personal data by other legal means. So obtaining consent, like at first sight, always looks like a very safe alternative. It is to a certain extent, however. If you think of obtaining consent from someone in order to process personal data, you always have to ask, maybe I need the data for the contract performance. Why? Because the service I'm selling just requires that I'm collecting and using that personal data. So for example, if I buy something at Amazon, of course they need my name. Of course they need my credit card information in order to process the payment, right? So it would not make sense for Amazon to obtain consent from me to give them my credit card data in order to process the payment. Why? Because it's already needed in order for them to perform their contractual duties. And in the law, there's actually a statutory permittance saying, well, if you need that particular personal data in order to perform your contractual services, then it's fine. Right? The third question you would ask, am I allowed to process personal data? There is something like a balancing of interest. This is sort of a last regard, right? You would always look at, do I need the data in order to perform my contractual duties? This is the question you would ask up front. It's the first question you ask. And if your answer is no, you would think of, well, maybe then I need to get a consent from the data subject. I come to consent a bit later because consent is tricky. Why? If you have a consent needs to be given by free will. Like I said, that means, on the other side, once you obtain consent from a data subject, the data subject can always withdraw it. This is the nature of consent. You can always say, well, right now I want to stop. And this is quite tricky for you, because once you integrated that set of data into your business process, and now the data subject comes and says, well, stop, I don't want you to process any more my personal data, you would need to have it removed from your systems. That can be quite painful depending on how your process is designed, right? So if you don't really need consent, this is not the road you want to go down, right? So this is like the last resort thing. The third party interest thing. I want to give you an example for that. Let's say you're Amazon, you're an online provider, you have an e-shop, and you're collecting credit card data. So what you would usually do is a fraud check. They're like databases where you just like send the credit card data to, and they tell you, well, the credit card data is blacklisted, or it doesn't even exist, the number is not correct, it's invalid. So it's like a fraud check. You would have that in many business models. It's not really needed, it's not really strictly necessary to perform the contractual duties. Why? Because if you see, well, that credit card is not going to work, then you would just ask the customer to use another payment method, right? It's possible. However, that particular proceeding, a fraud check, a checking of credit card data, you would usually say, well, that's a legitimate interest of, let's say, Amazon. So data protection law says, well, then it's okay. Right? This is a good example for legitimate interest, but this has a very narrow scope. Another topic that is, I think, maybe the most important one for each and every one of you. Why? Because in the B2B, you're usually acting as a service provider to your customer, like you do, for example. In order to bridge the gap between your customer and your customer in relation to its end customer could always say, well, I get the data, why? Because there's a contractual performance. Because I want to sell gas, for example. Your customer doesn't really need to transfer the data to you, but in fact he could do it himself, right? The services that you're offering, like in theory at least. This is how data protection law guys think, unfortunately. In order to bridge the gap between your customer and you need some sort of a legitimate basis in order to transfer the data from your customer to you. This is where data processing on behalf comes into play. So you have right now in German data protection law, in the Bundesdatenschutzgesetz, BDSG, you have section 11, and that covers data processing on behalf of another controller. So you would be acting as a processor, your customer would be the controller, and your customer is allowed to give you the data to be processed on his behalf by you once there's a specific data processing agreement in place. So I don't know if you already spoke to customers, if that already has been a topic, but I'm sure if you start to, then this is one of the first things that they will give you within their set of contracts, right? I'll come to that in a second, because this is where now strategy starts from a data protection perspective, because it could be really good or really helpful for you, for example, to establish your own set of documents for that purpose. Why? Because otherwise you're working for 10 different customers and you would have to check 10 different data protection agreements. Doesn't really make sense for you. So that could be something for you to think of, to have one standard model agreement that fits your business purposes, and you can hand out to customers and say, well, see, that's my model, we can use that. Right? So this would be a practical approach in order to look after your interests here. Well, and then we have other requirements under national laws. Let's look at what's going to be in the future. Right? If you have questions on how the situation is right now, just go ahead. But let's talk about consents, for example. Let's come back to Amazon. I always come back to Amazon because it's a good example. Let's say Amazon wants to send you marketing emails. Let's take Daimler. They want to send you marketing emails. They want to do advertising, right? They need a consent for that, actually. There's no legal basis for sending advertising emails. Why? Because there's a law in Germany. It's law against unfair competition, and it says you need explicit consent for that, right? First thing, consent. If you obtain consent from your customer, does it need to be in written form, like handwritten signature? Any idea? Well, certainly not in the online sector. This wouldn't work, right? So this is something that even the data protection lawmakers recognized quite early. They said, well, there's digital age and so on and so on. So it doesn't necessarily have to be in written form. Other employment. If you get consent from your employees, and this has just been confirmed by Federal High Court, it always has to be in written form when it comes to data protection, right? So keep that in mind. There's a big difference. And now the funny thing is the bundling. We talk in the bundling means let's pick a good example. I'm a telecommunications provider. I want to sell my services to you, and I'm saying, well, you can have my services, but I want you to give me consent that I can send you marketing emails. Right now, depending on how big the service provider is, right, talking about like monopolies, that would even be okay under actual data protection law right now. In the future, under GDPR, that's going to be a huge topic, because the law says you're not allowed to bundle these two things: the contractual performance on the one hand, and then consent for other purposes that are not strictly related to your contractual performance. So in the case that I just build up, the telecommunications provider saying, you can have my services, yeah, you can do that, but you need to give me consent that I can send you marketing emails or use your data for other marketing purposes. There could be trouble in the future, because under GDPR, this at least is what the law says then, you would not be allowed to do that, meaning that such a consent would be invalid. So that's bad, right? So keep that in mind. There's a huge discussion going on right now just around that topic, right? That bundling topic. There's going to be some more development, I think, because it's very strict as it is in law right now, and I wouldn't think that it's going to be as strict as people discuss it in the end. So this is just something for you to keep in mind. Data processing agreements, I come to that in a second. Employment data protection law, we touched it a bit. If you have questions on that later on, happy to answer them, but I think it's a very particular topic. So, General Data Protection Regulation from May 2080 on has a few really new topics that are really crucial. The things we spoke about right now, to be honest, you can handle them. They are a bit different. Why? Because we're talking process topics. Accountability and documentation. You as a company, and fortunately, you as a company, you're all quite small right now. So I would assume no one here has more than 250 employees. Because under GDPR, this would be like the benchmark to be like a normal company size or a smaller company size. For smaller companies, you have a privilege when it comes to documentation, depending on what sort of data you're processing. So from the use cases that I learned about, I would say that documentation may be something for you back there, could be something for you. Need to look in it in a bit more detail. But for the other ones, it would certainly not be. Why? Because you're not really processing any sensitive personal data. So, be subject to documentation requirements. What would you need to do? You would need to document in a very detailed manner all procedures you're running with regard to personal data. Yes.
What about CAD data?
CED?
CAD.
CAD data. Well, it depends what's in there. What could be what personal data could be in there? Help me out.
Measurements of people, for example.
Yeah.
Okay.
Could be.
But it's very no.
Well, but it's a good point, right? Because then, and that's funny, because then, let's say you would do something with like face recognition or something like that. Could be, right? This could be even a case where, notwithstanding the size of your company, where you could get into documentation requirements after all, because you're then processing a very specific type of personal data, where data protection law says that's sensitive, right? That's a good point. Now keep that in mind. That could be. Let's just assume for now that your companies would be subject to that. You would need to have a register. Most companies, they just have an Excel file, right? And they just start procedure 1. And then there's procedure 1. Let's say, for example, like companies have a procedure, usually SAP. This would be one procedure for them. Because everyone has some sort of an ERP, like an enterprise resourcing system. Could be SAP, could be, I don't know, whatever. And so they would have like procedure 1, could be SAP or whatever the application is called. And then they would describe what's the purpose they're using it for. For example, administrating like sales and whatsoever. What type of data is in there? You would say like customer data, and would maybe describe like customer name and contact data, email addresses, supply, purchase data, everything. Then you would, at a very basic level, describe technical and organizational measures, like who has access to the system, how's like password how's password management, how's business continuity, so like basic standards. And you would describe that within that document, right? And you would do that for all the procedures you're having that in fact are processing personal data, of course, right? So if you now look at a huge organization like an OEM, you can easily think of how big that documentation is going to be. I'm doing one right now for a company from the automotive industry. And we just got started, and I have on my table Leitsordner, that much. We just got started, right? So the bigger the company, obviously, the bigger the documentation gets. However, even if you're a small company and you fall within the scope of documentation requirements, this is something you should think of at an early stage, how you can manage that. Why? Because once you start your processes, your proceedings, your business, it runs, and then maybe 1 or 2 years later someone tells you, how about the documentation? And then you need to go back, retrieve all the information, so that's quite painful. I can, if you would like to, I can send you it's in German language right now, but I can provide to you a model how a documentation would look like under GDPR, so you could get a better impression. So maybe this is something that could be helpful for you. If you want to, we can combine it with the documents later on and send it around. Right? Gives you a better impression. Next concept: privacy by design, privacy by default. What does it mean? Actually, it's something that you would need to be required to do under applicable laws right now anyways. However, now it's in the law. If you're now designing a business process, GDPR tells you, like right at the beginning, you have to check how will I be able to implement data protection law requirements. Because to be honest, usually data protection law is something you look at in the end. Right? Usually this is how it works. This is what I experienced. But privacy by design tells you, well, it's something you should look at from the start. You should think of how could I implement data protection requirements from the start into my business model. So this is something that you should really take care of. Information and notification. Well, if you don't have much contact to end customer business, then this is usually nothing you would really be too worried about. But if you're selling your services to your customer and your services is collecting personal data, you're processing personal data, to some extent you need to inform your customer how you process personal data. If you process personal data of your customer on behalf, and this is usually based on the data processing agreement, usually all the information necessary will be in that particular data processing agreement. So usually you should be fine with that. However, once you're getting into contact with B2C and end customers, then you usually have something like a data privacy policy and so on and so on. This is what this is about. And now the fun part starts, right to be forgotten. We talked about access rights earlier, right? Data subject approaching you and saying, I would like to know what sort of personal data you have stored. So the first trouble is going to be for you to retrieve the data, because you have to inform the data subject, you have to reply to that. That's in the law. And what do you think? How long would be like the time spent for you to reply to a data subject? I would call you up. I would say, well, I'm a driver of the car. I got the gas from that particular service provider. I know that you're hosting the entire systems. I would like to know what's on your system. And I would like to know it now. What does it mean? How long would you have time to reply to that? 1 day, 5 days, 2 weeks?
No, less than 2 weeks.
Less than 2 weeks?
Right now, yeah.
Okay.
Depends on the amount of customers which are in the system, but I would say probably more than a week.
Yeah.
Between 1 and 2 weeks, I don't know.
The law, in fact, says you have 4 weeks, which I think is still comfortable if you have the right procedures in place, right? So this is like, as a general rule, the law says 4 weeks. In exceptional cases, you can take a bit longer. So if you design the process, you should always keep that in mind. So 4 weeks is like a good benchmark. Right to be forgotten. Some of you might have heard about that entire Google discussion about right to be forgotten, that people requested like erasure from data from Google servers. This is actually where this idea comes from, right to be forgotten. So if I, as a data subject, I'm approaching you, I say, well, I want to know what data you have, and then I say, well, that particular data I want to have erased. Let's assume that particular data is not needed for contract performance, or there's no like statutory law telling you to store that data for a particular purpose, like retention periods, like tax retention or something like that. So basically you could erase it and nothing would happen. It's quite hard for you certainly to find out where the data has been stored, because actually you would need to go all over your backups and check where's the data. It's not that complex. Why? Because even the lawmaker recognized that a company usually has data backups. And then when it comes to the right to be forgotten, yeah, in theory you would need to check all your backups, and no archiving systems and whatsoever, right? But it means in the end, it's usually not enough just to remove the data from one system if you know it's like on 10 other systems. So you need to have a process for that. Because if you have a data subject like a guy who's really annoying and he's really pushing you, you can actually do that. So it's always good to have a process for that in place. Data portability. Usually that's not going to be a topic for you. It should be a topic for your customer. Let's go again to your example with the gas stations. Perfect example. You have a customer, your customer has a customer, and let's say, for example, there are 3 competitors in the market offering these networks of gas stations, right? Whatever it is. And that particular customer says, well, I got my gas for my electronic car, for my battery car, from your customer for a year. I'm not satisfied anymore. I want to switch over to another competitor. Under certain circumstances, that customer could say, well, I want to have my customer data that your customer in fact, store. Please give it to me in a readable and in a usable format so I can take it and bring it over to your competitor, which makes it quite easy for me to switch from one supplier to another, right? Basically, the idea was the following: everyone looked at Facebook, right? They wanted to sort of provide the chance to customers to easily switch from, let's say, Facebook to Google+. This is where the right for data portability actually comes from. What they didn't think of was like they opened Pandora's box with it, because they thought of one particular use case, the Facebook use case. But right now, this thing is going to apply to banks, financial institutions. So if you want to move your konto over from Deutsche Bank to Commerzbank, this usually applies. And that's going to be trouble for banks, right? Same maybe with your customer. So if you are acting as a service provider to your customer, you will usually have a rule in your data processing agreement addressing this particular topic. Why? Because once you are providing the IT services to your customer will ask you, well, maybe someone comes and asks for data portability, so your customer has to make sure that he can comply with that. And so your customer will ask you and say, how are we going to do that? So he will ask you to implement some sort of a solution for that, right? So, but that's not based like in a relationship between you and the end customer, because you're not talking to the end customer. So customer talking to the end customer, but your customer is certainly going to ask you, how are we going to comply with that? So it's going to be, it's one part of your service. And now PIA, Privacy Impact Assessment. We have something similar already in Germany right now. It's called Vorabkontrolle. So if you have a procedure that looks sensitive because you use healthcare data, for example, under German law right now, your data protection officer, how many of you have data protection officers? The camera is pointing this way, so you can just... Okay, so everyone has a data protection officer. Right now, your data protection officer, let's say for example you're processing healthcare data, then your data protection officer would be required to do a Vorabkontrolle and see, well, it's very sensitive data, he would need to check, do we have all the safeguards in place, is that in line with the law, and so on and so on. The same as the privacy impact assessment, right? And so what companies will have to do in the future, if you set up a new business process, you will always need to check, do I have very sensitive data? Do I use technologies that might impose a certain risk for the data subjects? Authorities always say that cloud is a technology that imposes certain risks. Quite interesting, because you know that better than I do, that basically everything is cloud-based right now, which would actually mean that everything would need to undergo privacy impact assessment. In fact, right now, the advice we're giving to companies is run a privacy impact assessment on everything. And if it looks not so troubling, well, then you just confirm and document where it's all right. So this is what we advise companies right now as a standard process. Just run a privacy impact assessment on everything, just look at all the procedures. But it's usually focusing, like I said, on sensitive data, healthcare data. It could be data relating to employment data. This is what the authorities say. It's still under discussion. So companies would need to implement a standardized process in order to screen business procedures before going live with them, in order to make sure that all the data protection law requirements are met. We talked about documentation. I will send you a master document for that later on. Security of the processing. This is something that every one of you, if you look at data security, you would certainly have in place, right? That not everyone can access databases, you have passwords for your computers. I mean, all of you, you're only working here in that space, or do you have offices somewhere else? What's all here?
Somewhere.
Okay. Okay. So depending on where you work, there could be like requirements for where your server's located. Do you have like a separate room for them, unless you host it somewhere else? So this is like the basic security of processing. However, what you need to have in future, you need to have a standard concept for your security requirements somehow documented, because your customers will ask for that. If you are going to work for an OEM as a service provider, you will have to sign a data processing agreement. And attached to that, they were going to make you provide a data security concept. Depending on who you're talking to, that could be more detailed or less detailed, but this should be something that you should have ready once you start talking to them, because this is a standard procedure. They will all ask for it. Data breach notification. This is nothing new. This is already in law right now. If one of your employees takes your customer database and sells it out on the market in the dark net, for example, that's a data breach, right? And if the data that has been sold is now credit card data, and there's a certain risk that the credit card data is going to be misused, there could be trouble for the data, such as for the owners of the credit cards, then you would need to inform first data protection authorities, and second, if you have the information, you would need to inform the holders of the credit cards in order to make them aware of the fact that their cards have been breached, and so on and so on. This is first a huge process issue, because you need to have a process for that in place, right? Second, it's a super GAU in terms of PR, right? Because you have to openly tell the world that you have these are like your customers you're working for. They pay you. You have your employees, you have freelancers, you have suppliers, of course. I don't know, like a Microsoft or whatever. Partners, R&D. Don't forget that. One thing, because I get asked that a lot, if you're still in the testing phase, sometimes you need real data for that, right? Because you want to check if your system is running correctly or not. Is that data protection law relevant? Of course it is. It doesn't matter if it's like, if it's just a check or if it's like a real operation, right? So if you're using real data, even if it's just for checking purposes, on a secured environment, you need to obey to all data protection rules that are applicable.
I have one question to
Yes, please.
freelancer and partners.
Yeah.
If there is a freelance R&D partner, one person who signed an NDA and everything, can we handle it as employee or partner?
That's one of the gray areas for data protection lawyers. So usually what companies do out there, they treat freelancers as employees from data protection law perspective.
That's what I know, yes.
Yeah, this is what most of them do. Some companies that apply a very strict view on that, they would have some sort of a data processing agreement with freelancers in place. I would always say it depends on how you integrate them. If they bring in their own devices, if they entirely work on themselves, right? They bring in their own laptops, they bring in their own tools whatsoever. You should think about having some sort of a data processing agreement. Why? Because you're not really in control of the hardware that they're using. So this is the basic idea, to have some like a basic setup of data processing rules in order to make sure that you have a contract in place covering like IT security and basic data protection rules. So this is certainly advisable. Still, I know that most companies don't do it, right? But in this case, you should certainly do it. Yeah.
Should we inform our customers, for example, okay, we have this and this employees or freelancers working for us? Because I know it from the past. I used to work as freelancer, and it was never mentioned. And sometimes we thought, okay, I'm freelancer, but it was just okay for customers. But how to handle it if we have freelancers? How to handle it with Daimler or?
Some customers will make you tell them, so they apply very strict view. They say, your freelancers, they are nothing else like an external subcontractor. Meaning, for example, if you involve a new freelancer on your team, they will make you tell them, and also will make you have the exact contractual framework that you have, for example, with Daimler in place, to like take it and make your freelancer sign that as well. I know other companies, they have in their service agreements a provision and setting definitions and saying, well, a freelancer is like my employee, so there's no notification obligation on that. So this could be one thing you could try in the agreement. Then at least you have an agreement with your customer, and you're not in breach of contract if you don't inform them. So this could be something that some companies are doing, right? But again, it's a gray area. So usually your customer is going to ask for that, maybe not. If they're not asking, this could be something you could think of addressing in the agreement, right? And if you have the chance to get a data processing agreement with freelancers in place, you should try, right? They don't have to be so substantial. So usually data processing agreements, depending on how much you want to have in there, but if you have a short form, this could be like 3 to 4 pages, standard document, right? These are standard rules. If you look at the Daimler's data processing agreements, that's way bigger than that, right? So it's not going to be 4 pages.
Maybe there are 2 pages with a lot of links to different other
possibly,
documents.
Possibly. Depending on what they include on it, right? So, what are like the, let's say, hotspot topics? Because right now we just talked about the players, but what are like the hotspot topics that that we are dealing with right now in automotive and mobility? So the first thing we talked about that, it's data subject rights, right? Because right now, connected cars, telematics, and so on, you're collecting data, collecting data, right? And if now one customer comes and says, I want to have access to that data, you usually have a chain of service providers all working on the same databases. They all have the same data somewhere in their systems, right? And that's then going to be a problem once someone claims data deletion. Everyone needs to have a process for that in place. Privacy by design and connected cars. This is obviously something that everyone right now looks at, but and this is the point. What I usually experience that in the R&D process, everyone's developing, and then someone in the end, someone asks, well, how about data protection? Should be the other way around, right? It's annoying. I know, it's annoying, but it certainly makes sense.
And it's not agile.
I'm sorry?
It's not agile.
Yeah. Well, but it's one core. Let's say it's one core requirement. Think of data protection very similar to what cartel law is right now. So if you work for an OEM and you say I want to be agile, yeah, we have like a competition law topic here, but I want to be agile. You know what the answer is going to be, right? So think of it as quite a similar topic. Big data. Everyone talks big data. Everyone has huge data and everyone wants to analyze it. The problem with data protection law is you need to tell the data subject when you collect the data for what purposes you're going to use personal data. So if you collect the data because they want to buy gas and you use the data later on in order to run analysis with personal data, obviously. If you have anonymized data, it's no data protection topic anymore. But if you use like that entire set of data that you're collecting to do analyzing with that, that's usually not the purpose that you collected the data for. So you have 2 possibilities. Either you inform the data subject up front and say, well, I'm using the data in order to fulfill my contractual performance duties. But I will use the data also for other purposes, like 1, 2, 3, 4, 5. Next step, you would think of, is that covered by like the statutory permissions that I have, or would I even need to get consent for that? Marketing, for example, right? But still, it's all about information on the data subject. Data ownership. So this is like, let's call it the holy grail. Who owns the data? Who owns the data from a connected car? Simple question, right? Who owns it? I own a car. I have a connected.
So it's data, isn't it?
Well, let's assume it's not. Who owns the data? That's the interesting question, right? So for right now, we would say in Germany, there's no rule in order to determine the ownership in that data. This is why usually companies that are collecting technical data from connected cars, they would always try to have some sort of a provision in their agreements to cover that issue. Let's say in the contract with you, driving that car is also owned by the bank. The bank will certainly say, well, what do I know that data? I don't even know what the data is. I don't need it. I don't want to have it, right? OEM says, well, I want to have it. Of course, predictive maintenance, etc., etc. So this is going to be a big topic, but again, once we're talking personal data, this is like the primary topic.